The last thing I wrote down was, so, times have not moved on.
Well, let me go back in time and deal with a little bit of housekeeping, if I may.
Sure.
Disrespect, Your Lordship, dealing with Lady Justice Whipple first and her query over the 20% of the damages. Quite understand why the query was raised. It is recovered from the other side. It appears on a cost bill, and the defence insurers, or in this particular case, the Motor Insurers Bureau, covering those insurers, pay that sum. In respect to Your Lordship's query, or what I was going to find, I don't have my finger on it, about the vulnerability and adjustments for vulnerability being recoverable in costs. Now, they were dealt with at the 2021 amendment that we've seen at Rule 44.3 in the cost rules. That's at tab 8, page 111 in the authorities bundle.
Just give me a moment to get it over there. 111.
111.
Thank you.
It's 44.3, basis of assessment. Subparagraph 5 at the bottom of the page defines what costs incurred are proportionate if they bear a reasonable relationship to, and then there's a number of subparagraphs. The additional one at F over the page that was inserted is any additional work undertaken or expense incurred due to the vulnerability of a party or any witness. So that's in mainstream, what I'm going to call, for the purposes of this argument, mainstream litigation, not fixed costs. Now, what happened with fixed costs is that Your Lordship will, I put it in my skeleton argument that the Lordships Hodgebridge and Leggett refused permission to appeal, saying there's no point of law of general importance, but they also said the order added the panel expressed the view that it's appropriate the Civil Procedure Rules Committee consider the matter.
Just where are you in your
Paragraph
skeleton?
30 in my skeleton.
Thanks so much.
Bottom of page 66. Now, we know that was done because you have the supplementary bundle before you, the white bundle, I think, certainly for two of the bench, that produces the new rules that came out a few days ago. And in particular, the proposed new rule 4510. Now it's on page 11 of the document itself, if you don't have a bundled pagination. (4510) is headed claims for an amount of costs exceeding fixed recoverable costs of vulnerability. Says the court will consider a claim for an amount of costs excluding disbursements which is greater than fixed recoverable costs where a party or witness for the party is vulnerable. Vulnerability has required additional work to be undertaken. By reason of that additional work alone, the claim is for an amount that is at least 20% greater than the amount of fixed recoverable costs. So it's got to be a significant sum that's been expended, it seems. But the provision is there in the rules. So going back to where I was just before the short adjournment, when the new rules came in as to vulnerability, it emphasises my point that fixed recoverable costs were out with or had been carved out of that as to the cost provisions, not the overriding objective provisions, but as the cost provisions, as to how they are to be dealt with, and they are now going to come in force after we've forecast, as best information we have, after the 1st of October. And that, of course, will tie in also with receipt of interpreter fees. Two more matters, if I may, having had instructions over the short adjournment, because it is a central or a plank in our argument as to access to justice. The interpreters, I understand, are held on panels and schemes where they may be warned for a court hearing, but to Lord Justice Snowden's practicality point, unless they turn up and interpret, they don't get paid. So it's a lot of firms enter into bulk collective, but they're on a panel. I'm not saying that's in every case, but that's certainly known in the industry.
Yes, so you've got to. I think my only point was you will doubtless book the interpreter ahead of the hearing.
Yes.
And so, in a sense, whether the case settles or not, I obviously we're getting into some really granular detail here, but I don't know whether they, if you disappoint them on the day, as it were, or they attend at court but aren't required, you still have to pay for them.
Well, I suspect if they attend, one thing, but it's
you might be able to cancel at short notice.
Certainly, larger the firms. There's a lot of interpreters, a lot of this work going on in the lower courts, and it is a factory-like. And some firms, larger firms, will have their own arrangements with the interpreters because there's many of this type of case.
The only time I've seen any contractual arrangements about provision of interpreters, the contract was 340 pages long. And we saw that in the context of the Sheffield Crown Court docking someone, can't remember who, half of the interpreter's fee because the interpreter didn't turn up or something, or half their daily fee. Yeah. They didn't turn up. And when the Lord Chief Justice, Lord Thomas, asked counsel, who was probably of about 2 years' call, to interpret the contract, she practically fainted, which is for the reason why I remember it. But the contract was about 300. And the point behind what I'm saying is that, particularly in light of you saying there's a lot of it goes on in the lower courts, there's bound to be bulk agreements. Yeah. And this was an agency, really. There's going to be a bulk agreement with the agency, which we don't know about.
No, we don't. But it's the way the system was. Similarly, final point, the risk of incurring such fees is, or indeed any disbursements, because if you lose, you may be responsible for disbursements, and even under a conditional fee agreement, insurance is available. After the event, insurance is available. You don't even pay up front. But if you lose your case, you don't have to worry about paying any expenditure. The convert, of course, where they make their money is on the cases you win. They make their money. They win. So the risk of actually incurring, for example, a £924 fee for many claimants can be obviated by the fact that if they take up an offer of HHJ insurance, and solicitors under their duties have to explain to the clients and potential claimants the best way forward for them in the exposure. So that's often a product that's available in the market.
Sorry, I'll go back. We're on HHJ insurance.
Yes, just if you lose a case under the CFA, the client still would be responsible for disbursements. I see. They're not the profit costs. But if they spent money on medical reports, spent money on...
So does that mean if the client, well, maybe it doesn't matter, but the point you're making is if you lose the case, the claimant loses the case, they might have to pick up the £924.
Might have to, depending on the terms of CFA.
You're getting a shaken head behind you, but it may not matter.
Well, that's because they may have insurance.
That's because he said, yes, exactly.
Yes,
because he's saying
it depends what the HE says, but many of them will take at HE.
Got it, yep, thank
you. Themselves. So that brings us to the meat of the argument that you want to hear from me on, having dealt with what we say is quite an important point about the access to justice, which really is now dealing with the interpretation of the rule, and there's only one place to start, I suppose, which is the rule itself, 45, in summary, the H rule. I have to be quite short. Mr. Williams knows the brevity of my submissions from previous cases, but the fact of the matter is that on page 149 of the authorities bundle in tab 9, we have the rule of disbursements. The first thing I would point out to the court is, in looking directly at this rule, one is not ignoring assistance to be gained anywhere else. And I think it's important to note that a criticism was made of Lord Justice Coulson in the learned friend skeleton that he was refusing to look elsewhere in the CPR, and he should have done. But the fact of the matter is that Lady Justice Nicola Davis and Lord Justice McComb both indicated it may have not been the most entertaining day in court to do that, in the words used, but it was useful. And the fact of the matter is they both agreed with Lord Justice Coulson's decision on the issues before the court. So even if he is to be criticised for not doing that, there was a safety that the two other members of the court did so. Here we have in 4529I we have subparagraph 2. I draw the court's attention that in a claim started under the RTA protocol, this is what we're concerned with, the disbursements referred to in paragraph 1R. Now, that's of note in our respectful submission.
Sorry, I've lost the page.
Okay, it's page 149.
Oh, sorry, you're in 40. Sorry, you are in 45.
Yeah,
yeah.
I'm actually in there. Sorry.
Yeah.
It's talking about disbursements being allowed in paragraph 1, and says that paragraph 2 in a claim started under the RTA protocol, and that is fairly straightforward language. If you log into the electronic system and go into the RTA protocol, you have started a claim. That is to be contrasted to H further down, when the words any other disbursement reasonably occurred due to a particular feature of the dispute. We say from that the court can take notice that these are cases that will go to trial under this provision if they don't settle the draw of the court. At a point I made just before the short adjournment, the court may well have read the court file prior to the party settling and will be aware of the dispute, and even if it goes to trial, even more so, aware of the dispute between the parties. And therefore the court is in a perfect position, as these are dealing with trial costs, to distinguish what, or identify what the dispute is. In our submission, we also distinguish the dispute from the claim. The claim can be claiming everything. By the time you get to trial, heads of damage may have been agreed, but we know what the disputes are left at the hearing. And therefore, the juxtaposition of paragraph 2 of the claim started under the protocol and paragraph H of the particular features of the dispute fall very naturally into the reading of the words. And it also ties in, if I may be so bold, my Lord Justice Snowden referring back to page 147, referring to costs about any amount in dispute, because that is also a cost order at the end of a hearing, and the court will know about any amount in dispute. And that's under paragraph 4529F.
I do notice, incidentally, that in Lord Justice McComb and Lady Justice Nicola Davis's judgments in Cham and Aldred, I mean, although they make, one of them at least makes a general proposition, you've got to look at the CPR as a whole. In fact, they both say what actually they found helpful was looking through CPR 45.
Yes.
And the different parts of CPR 45.
Yes.
As opposed to ranging further and wider.
I was wondering when I first read this as whether and how the courts approach part of 36. They always kept calling it a self-contained regime, and therefore one has to only look there. I wouldn't restrict the court, any court looking at this, not to look outside part 45 if there's any assistance. But there seems to be a lack of particular any assistance. You've heard from Mr. Williams about his particular submission, where the word it all started of claim and or dispute. But here, I would pray an aid before the court as the cost draftsman making a deliberate choice to distinguish the word claim from dispute when it comes to the paragraph H under 4529. Now, one matter that was troubling my Lord Justice Stuart-Smith was the, I think you described as the personal characteristics of F&G, the expenses and the loss of earnings, etc., although I think you had not formed any particular view. I would submit on behalf of the defendants that this isn't a necessarily cumulative or combined entry where each has to be similar to the other. The point is dealt with in the judgment of Mr. Justice Coulson, and I flagged it up earlier, that is this rule really supposed to list every single disbursement you could have, or is it and I do not go down the road of saying it's a catch-all. It certainly is not a catch-all, because these are restrictive fixed costs. The idea is to keep these costs restricted, to being fixed and being proportionate.
No, the idea here is to list is to identify the criteria for disbursements that can be recovered
Yes.
over and above.
And also these, and in addition to that, I totally agree with that. In addition to that, from A to G, sums that are readily identifiable in a personal injury action. So, for example, you've got the medical records and medical expert in A, non-medical reports in B. For example, there may be a care claim, even if it's to do with a relative looking after somebody in this level of case. Cost of specialist advice or counsel is provided from the relevant protocol. Do with quantum often. Court fees, any expert's fees for attending the trial. Well, these are all to be expected. F, expenses for a witness to attend, that would be expected. And G, similarly. I would draw issue if your lordship was going in the direction to say as a matter of interpretation that what is in A to G should necessarily determine what should be in H, simply because of the particular wording in
There
it.
is, if your touchstone is what is to be expected, the touchstone might well be that if in order for the claimant to participate at all meaningfully, he has to have an interpreter here, you could recover that too.
They could have covered that too.
No, he could recover that too.
Yes.
You've been going through these saying these are all what you would expect.
Yes.
Well,
Yes, and that's exactly the point I'm making, my skeleton, my lord. Those drafting this, knowing full well the range of fees and expenses and disbursements normally incurred in personal injury litigation, have chosen not to put the word interpreter in this list. And it's a point that the learned friend kicks off with that in his skeleton argument, and I took issue in mind that if I'll give you the words he used, it's of note. He says the cost of an interpreter will be obviously both foreseeable and essential in a wide variety of litigation. Those are Mr. Williams's words, paragraph 9 of his skeleton. Mm-hmm. And our submission to the court is, well, the drafters of the rules did not go down that road, did not allow for an interpreter. And what they did allow for was a phrase we're all too well familiar with now, a disbursement reasonably occurred due to a particular feature of the dispute. Now, may I turn to the judgment in Cham, because you will recall that Lord Justice Coulson went with the two competing judgments from Master Campbell and His Honour Judge Graham Wood, the senior civil judge in Liverpool. He found favour with the interpretation by His Honour Judge Wood. And can I just take you to a passage in that when he examines that interpretation, or his judgment. It's a page 331 of the judgment in Cham. In particular, it's a breakout. He's reciting the judgment.
which paragraph?
Paragraph 15 of the breakout. Well, I have to read the last few. I have to read the last few lines of 14. But in particular, when he looks for the reason for this rule.
You're looking at 14 from the citation.
Page 331 is a breakout, paragraphs 13 to 15 of the judgment, and I'm looking at the end of paragraph 14 and paragraph 15 in his judgment.
Right.
And in paragraph 15, it says it seems, it's typographical error, that it seems to me this is the correct approach. Otherwise, the drafters of the rule would have been quite careful in the way that they've defined the recoverability of disbursements. I made it clear to counsel in the course of exchange I do not accept it would be appropriate to describe sub-rule D as a catch-all or a sweep-up provision. If the rule committee had intended this to be broadly defined, it seems to me the qualification would have been in terms of such as any other disbursement that's not not recovered by the above situations. In other words, in anticipation, the foregoing situations are apparently exclusive of other situations that might arise. Instead, the rule drafters chose to use a particular description which this court has had to define, and that is whether the disbursement has arisen due to a particular feature of the dispute. And just on this similar point, Page 335 in the judgment of Lord Justice Coulson touches on the same point of paragraph 49, my Lord. When he's talking about the scope of argument about what's covered under the umbrella of fixed costs. And he's referring to 4529C in Table 6B, one of the tables we were looking at earlier, and 5-6 lines down, he begins a sentence on the right-hand side of the paragraph. In order to make it workable, Table 6B cannot set out in grinding detail each and every one of the work items deemed to be included within the fixed recoverable costs at each stage. If it did, it would run to scores of pages, and disputes about any items that may have been inadvertently forgotten would be numerous. Instead, it operates on the premise that all the costs which might ordinarily be expected to be incurred up to a particular stage of the case would be deemed to be included in the amount stated by way of fixed recoverable costs. That's dealing with profit costs. Then he says this: disbursements, on the other hand, are one-off items which are for specific items of work. They're not easily addressed by reference to the same general considerations noted above, as the need for them will depend on the particular circumstances of the case. Accordingly, the rules simply provide that where such disbursements fall into one of the categories, 29L2, they will be recoverable in addition to the fixed costs. And so, and a point I made earlier, that the additional provision in H is very particular, not as His Graham would have stated, of anything not in the above, to paraphrase, but it is very particular as to a particular feature of the dispute. And I therefore submit that the narrow interpretation is correct, because it is not a wide addition. It is narrowing down to the word dispute in the claim, and it is within the regime of the fixed costs that are supposed to keep a cap on costs under the fixed cost regime.
I mean, you're basically saying you should adopt a narrow approach, because otherwise it would undermine the whole concept of the fixed cost.
Yes, when I say it's a fixed cost regime, it's there to keep a level on cost, keep a cap on cost.
I mean, as a general proposition, I sort of follow that. One of the points my Lord made to you was his, or in fact, he made it to your opponent, about the FG
yes.
categories. I mean, at least on the face of it, they don't fit Lord Justice Coulson's interpretation of H, in the sense that they do seem to relate to the characteristics of the person. They seem to stand separately from A to E, which are definitely all, as it were, process-related costs, disbursements costs.
Yeah.
F and G seem to stand a little bit out on a limb, because they do seem to relate to the characteristics of the person. I mean, if you the further away you live, presumably the greater the travel expenses you can recover.
Well, there's two elements to his decision, are there not? The first element is, what is the particular feature of the dispute? He deals with that at paragraph 36. Then he goes on to distinguish the particular case he has in front of him, dealing with the particular characteristics of a person. One could stop at paragraph 36. Can I take you to paragraph 36?
I mean, I assume you're going to say one answer to this is that H, in a sense, has to be read, or the fact that the two of the earlier subparagraphs might allow characteristic costs related to the personal characteristics of the litigant to be recovered in very specific, foreseeable ways, i.e. travel or loss of earnings, for witnesses as well, in fact, doesn't mean that you have to read H broadly, because H does have limiting words in it.
Certainly, I hope that perhaps I didn't make it clear enough when I directed my Lord earlier on, with regard to your conundrum with the fact that F and G are there, and how they fit in. And I was hoping to say that they're not they don't necessarily have to influence. They can't influence H, because H are particular. If H was, as His Honour Judge Graham Wood said, or if H was anything else to progress the trial, anything like that, it'd be much wider interpretation. But by narrowing down on particular features of the dispute and going no wider, then, my Lord, yes, I would discourage that line to take the personal characteristics as influence upon interpretation of H, and I would also agree with my Lord that H has to stand on its own, and does stand on its own. Can you give me a moment, my Lord? Yes, Mr. Dean reminds me that the F and G actually come from CPR 2714 with these small claim track rules as to what you can get. You see, you can't even have an interpreter whatsoever in the small claims court, whereas you can get the cost of witnesses coming along, and somebody has moved those across of that purpose in 2714.
So where do they come from?
CPR 2714, 1-4.
Well, you can have an interpreter in the small claims court, presumably, but you just can't recover the costs.
Well, that absolutely.
Yeah.
I wouldn't say he's part of the door of the court for coming in, no, but you don't get the cost back. Again, it's a question of disproportionality as you go up through the tiers. Yeah. There's no provision to recover the cost of interpreter at that level.
Just pause a second.
That's interesting.
Okay, just give me the CPR reference once more. CPR 27.1.
27.14.
Yeah.
14.
14.
Yeah, not one brackets, 14.
Yeah, 14.
Thank you.
And that then refers to the fixed cost attributable to that particular sort of claim.
Yes.
So we'd have to go foraging around in part 45 again, would we, to find out what the list is?
What the
list of recoverable costs is.
well, we basically F and G have been taken from the small claims track and placed in our above our H in our 4529.
Okay.
Give it.
Yes, it's D.
It's D and E.
D and
Is
D
it?
and E. Yeah.
What's the basis for saying you can't get interpreters in small claims?
They're not allowed. They're simply not allowed.
There's no costs at all, really, essentially.
No,
Okay, so there's no specific exclusion for them. It just says
No.
you can't get costs.
that's right. There's no provision for them. No provision for costs, in fact.
Yeah, I'm just sort of thinking about all the access to justice arguments. But that's a...
Well, again, it's proportionality that kicks in since 2013. Well, as I said at the beginning, going through the tiers, the greater the value of the claim, more is and maybe and is allowed. So, there's anything else from Lordships? If I can proceed, it's paragraph 36 where he deals with the particular, the Lord Justice Coulson deals with the particular interpretation of H. And he begins off with the wording, the particular features of the dispute in an RTA claim. Paragraph 36 at the top of page 333. Then he gives examples as to how the action happened, whether the defendant was to blame, nature, scope and extent of the injuries and their consequences, and other matters of that kind. For example, the particular circumstances of the accident may be sufficient and used to require an accident reconstruction report, or the injury is so complex they may require a number of different reports. Such additional involvement of experts may also require specific advice from counsel. Depending always on the facts, such costs may be said to be disbursement properly incurred as a result of a particular feature of the dispute. And it does give the court discretion, having actually heard the trial or read the papers, but the guidance in this court to date, which we seek to uphold, is that it's a discretion that's to be exercised by way of a narrow interpretation of the rule. And that's how we put our case. Now, I draw the distinction because that I say is the ratio.
I mean, in many ways, if you unpack it a little bit, it's a disbursement properly incurred. In a sense, in the resolution of the dispute as a result of a particular feature of the dispute. I mean, it's you have to test it by reference to what you need to have to resolve the particular issues in the case.
Yes. I mean, in this case, motorcycle defendant hits motorcycle of claimant. Or actually, the other way around. He pulls in front of him, slams him, slam on him, he goes into the back of him. But the fact of the matter is, who was at fault? And that's the issue. Who overtook who and who braked harshly, sharply. That's the particular feature of this dispute. The liability, and then there will be quantum issues. There may be matters not in dispute. I mean, for example, general damages may be agreed. That would not be a matter in dispute at the trial. So when we're looking at the ratio, I'm saying the ratio is in paragraph 36. The fact he's gone on and talked about other matters explaining with regard to the child as to age, linguistic ability, etc., is also part of his judgment. He actually deals with linguistic ability in that sense, as to personal characteristics. So, because that's how we put our case in upholding this judgment as still good law, despite the fact of the amendments, and you have my points before the short adjournment, the amendments as to vulnerability, the vulnerability wasn't specifically with regard to language that I accept. The person should have a chance to give their evidence in an understandable and understanding way. It doesn't offend the Human Rights Act either, and I've dealt with this in my skeleton. You have these points in my skeleton as to how we put our case. But at the end of the day, if we come back to access to justice, we stay, it is still there, despite the narrow interpretation. And Lord, I was going to go on to the new rules, but Mr. Williams kindly, having had them served on him, has dealt with them this morning as to what they say, and we've just looked at them again as to the cost provisions. So those are our submissions in particular, unless we can assist the court any further.
Thank you very much. That's very helpful, Mr. Mann. Yes, Mr. Williams.
My Lords, a few points in reply. It's not a case of swings and roundabouts. That's the mantra which we've had a number of references to, because swings and roundabouts are predicated on overcompensation in some cases and undercompensation in others. But the point is that on my learned friend's interpretation of the rules, interpreters' fees will not be recovered in any cases. So it's not a case where you're getting them in some cases and not in others, and you have to accept a sort of rough justice.
Well, nor is I don't know, can never remember which is a swing and which is a roundabout.
No, I don't think.
Nor is it being asserted that the interpreter's fee is in there, so that everybody is being overcompensated apart from those who actually engage in interpretation.
Monoclause.
What?
Everybody is being over. Well, that was the next point I was going to make. It's not a swing or a roundabout in the sense you get it in some cases, you get overpaid in some cases, underpaid in others. It's not swings and roundabouts in that sense. It also must be premised, and this is the point your Lordship has just put to me, on the proposition that the profit, what would normally be regarded the lawyer's charges, the 20% of damages that my lady asked about, for example, that somehow contains an element in respect of interpreters' fees. So the solicitors are microscopically overcompensated in every case involving a native English-speaking client, and from that they sweep up the inability to recover the disbursement in the cases where they don't have an English-speaking client. But the difficulty with that is that shoehorns the profit costs, which are the solicitors for the legal services they supply, for a function they manifestly don't have, which is to cover a disbursement. Because as we've seen, disbursements are recoverable separately under this regime. So to suggest that within the solicitor's allowance for the work they do, there is also some tiny allowance in every single case for the interpreter's fees that they have to write off, it is just misconceived, because it imposes a function on the fixed costs, which the fixed costs don't have. The fixed costs are there to pay the lawyers for their legal work. They're not there to cover things like whether or not your client needs an interpreter. So if I can switch the playground metaphor, the playtime metaphor from swings and roundabouts, what my learned friend is actually proposing is a game which is exclusively populated by snakes and doesn't have any ladders, because all you will ever face is a non-recovery. It also doesn't work on the facts, because if you actually look at the way the fixed costs work, I appreciate that my Lord Justice Stuart-Smith has rightly pointed out that the way the table appears in the authority bundle is very unhelpful. It is clearer in the white book. But if you look at the way that it's staged, the way in which the fixed costs are staged is that the final escalation of fixed costs occurs as of not at the date of trial or shortly before the date of trial, but on the date the case is listed for trial. Now, in these fast-track cases, the whole point about the fast-track is you're given a date at an early stage and you work towards it, and it's essentially immovable. So these cases are listed for trial pretty much as soon as they're allocated, so that you get a trial date at a very early stage. That's the point at which the costs go up. And then if you actually get to the trial, the only additional thing that you get is the trial advocacy fee.
So hang on. Your point about listing comes from box B, the right-hand column.
Correct, right-hand column. So
and the column before that.
And the column before that. So you get allocated.
So the day that the court sends out a letter saying this court case is now listed for trial on whatever it may be, the 1st of June, you then get
your escalation.
But the case settles before the date of trial. You get 2655 and 20%.
Of whatever it settles for.
If the claim is disposed of at trial, which includes settling on the day of the trial,
you then get the advocacy fee.
You then get 2655 and the advocacy fee.
And we say ex hypothesi, the advocacy fee covers the advocate. It's not there to cover the interpreter.
And if counsel turns up and fights the trial, and this fights quantum, then the decision of the court disposes of the need for an opinion.
Well, of course, yes, it would. Yes.
And if counsel turns up and it settles, he may need to go into court and just give his opinion orally, but that would be presumably be included in the trial advocacy fee.
Yes, I mean, obviously, all this presupposes it's a child or person under a disability. But in such a case, in all likelihood, the district judge who would usually be trying this would just interrogate counsel there and then for, well, what's your thinking? Counsel might say, well, my learned friend and I agreed the general damages were X, but we took the view there's a 50-50 case on liability, and so we've accepted a discount, or something of that sort. It would be dealt with ad hoc. So my learned friend's point about cross-subsidy between the solicitor's share of the costs and the disbursements, not only is it wrong conceptually, because it just isn't the function of those costs, and there's not an iota of evidence to suggest that these costs have been inflated above the level they would otherwise carry, because solicitors have to write off interpreter costs. And quite apart from the fact that Cham and Aldred came as a bolt or out of the blue on this point. I mean,
that depends on your submission which you made this morning, which I'm not asking you to...
I know you're not.
Which is that the fixed costs are for the lawyers' services.
Yes, it's the distinct. I mean, in the sort of traditional terminology of the solicitor's profession, the fixed costs are what solicitors call profit costs, and the disbursements are the sums that they have to pay to third parties.
So, to take a simple example, if, as in this case, a member of the solicitor's staff translates the witness statement, that would be in the fixed costs.
That's in the fixed costs.
Because it's a part of the legal service.
Yes. And in exactly the same way that Lord Justice Coulson found that on issue 2, you wouldn't have got the cost of counsel's fee anyway, because that just would have been wrapped up into what the solicitors get paid for already, because that's a supply of legal services, which and if solicitors choose to go to counsel, it still comes out of the sum that has been allocated for legal services. But my learned friend Mr. Brown is attempting to reallocate it from legal services to non-legal services, and that, in my respectful submission, is where his argument fails conceptually, quite apart from the factual point that I've just made about it just wouldn't work.
Okay.
Now, access to justice, it is all about access to justice, contrary to my learned friend's submission, because it does go as to the claimant's ability to participate economically. My learned friend errorly asserts, it doesn't impact on clients, it impacts on solicitors. And with respect to him, that is completely wrong-headed, because it treats this regime in Part 45 as a regime that has got any application to costs between solicitor and client. It doesn't. It only applies to the inter partes costs. It doesn't regulate in any way what solicitors charge their own clients. And in fact, Mr. Brown, in his submissions this afternoon, he actually recognised that solicitors will very frequently be unwilling to take on the burden of disbursements, because he explained to you that lots of solicitors even require disbursements to be paid if their client loses, and therefore clients have to insure against that. So that submission of his this afternoon, which is factually correct, is completely inconsistent with the proposition that solicitors just happily write off disbursements which aren't recovered. Solicitors don't do that. And in fact, in terms of what solicitors deduct from damages in successful cases, that is a sufficiently pressing issue that I had 3 days on that issue in this court last year before the Master of the Rolls, the Chancellor, and Lord Justice Nuji about the principles which are to be applied to what solicitors can fairly deduct from damages at the end of small personal injury cases, a case called Belsner and Cham legal. So I'm not relying on that as any sort of authority, because it doesn't deal with interpreters. But what it certainly does is to the proposition that in these small personal injury cases, solicitors just sing for their supper, and what they don't recover from the other side, they don't charge their client. It is just absolutely misplaced.
What's the name of that case?
Belsner and Cham legal.
B-E-L?
B-E-L-S-N-E-R. It was decided, I think, in late October. It was a bit of a cause célèbre for the sort of fast-track personal injury world. Like so many cases,
well, you'll have to forgive me for not being intimate.
No. What I was going to say is, it's well. You're sort of all so far above it. Leave it. And even my learned friend's point about ATE insurance, again, that also shows how this impacts on clients. Because obviously ATE insurance itself comes with a cost. The premiums are costly, and if you win, they're deducted from the damages. So again, Mr. Brown's own point about ATE, because you can't recover them inter partes. You used to be able to recover ATE insurance, but that was abolished by the Jackson reforms outside mesothelioma cases. And so those come out of your damages. So again, Mr. Brown's own submission, in fact, falsifies the proposition that all this is just sucked up by the solicitors. And in my respectful submission, in terms of access to justice, first of all, obviously, we can't know the cases which don't come forward because clients have language difficulties and they're now advised that they will have to pay for an interpreter. But there are also obvious issues about such clients if the cost of the interpreter can't be recovered. They suffer settlement pressure, which English-speaking claimants wouldn't be exposed to, because they're thinking, well, if I go to trial, in this case it's £900. I know there's been a certain contretemps about the composition of that figure, but the very experienced defendant counsel below didn't take any point on £900 being an outlandish sum for an interpreter to turn up at court for an entire day. Now, this actually is right at the top level of the value of these cases. This is a £20,000 case. But even in a £20,000 case, that's still 5% of the value. Lots of these cases are only worth about £1,500. So if you go to court and you've got to pay an interpreter, so even if it's only £500 you can't recover, you have a huge pressure on you not to go to court, which an English-speaking claimant wouldn't have, which again, in my respectful submission, shows it has obvious access to justice implications. Even if the solicitors did absorb it, as my friend's fancy would have it, there are obvious access to justice implications, albeit indirect ones, because it begs the questions of, do they take a case at all when they have to absorb from their margins a substantial expense? If they do take it, how do they resource it? If they are not going, if they're going to have to shell out from their own purse £924 for an interpreter, then presumably they'll be looking to make savings elsewhere. And again, do they take it to trial? I mean, or do they say to your client, I'm sorry, we can't justify taking this forward to trial. There's been a Part 36 offer, it's a bit low, but it makes no sense for you to go to court over, over perhaps getting another £500, when going to court will cost you another irrecoverable £924. And it is a very ordinary term under solicitors' conditional fee agreements. As you would expect, that they're not professionally obliged to take cases, to continue supporting cases on conditional payment terms if they have become uneconomical. So that's access to justice. Also, one mustn't lose sight in my submission of the fact that our case isn't just based on access to justice, it's also based on discrimination. Discrimination by language, and therefore indirectly by nationality and race, all of which I hardly need to elaborate, is unlawful. Potentially disability, I've referred to sign language. And in my respectful submission, once you remember this is about discrimination, it becomes quite wrong to talk about swings and roundabouts, because it doesn't help a party discriminated against to be told not to worry, your next door neighbour did perfectly okay. I mean, it just cannot justify in our submission a measure which discriminates against people because of their language and therefore indirectly their nationality and their race. And all the points I've already made about access to justice, the ability for them to find a solicitor, whether they're under settlement pressure, increased settlement pressure as compared to their English-speaking neighbour, in our respectful submission also apply under this heading. These clients will inescapably necessarily incur a cost as an inescapable aspect of the dispute resolution process their English-speaking neighbour would not incur. And in our respectful submission, their inability to recover them is troubling. And in our respectful submission, and I know this does begin to go over what I've said before, and so I'll say no more than this, it's also impossible to discern why anyone would suppose that was the policy of they that drafted H in its current form. I mean, on the contrary, it looks like the very sort of circumstance you might expect H to be addressed at.
Is there any difference between an interpreter and an intermediary for the purposes of this argument?
I'm not sure that there is. I mean, an intermediary, I think actually Lord Justice Coulson refers to intermediaries as well as translators in that passage of the judgment which we're concerned with. It's difficult to see that there would be a distinction between the two. Whether or not you could say that a translator is even more fundamental to your ability to participate, I would have to admit I struggle to give a sensible answer.
I mean, I can't remember what the test for an intermediary is off the top of my head. It's quite a while since I looked at it, but one assumes that the court wouldn't permit an intermediary to accompany a witness in the witness box without making a decision that it was necessary. Well, reasonably necessary, or at least a reasonably high degree of requirement. It's not something you just get on the hoof, in my recollection. In fact, judges, I think, tend to be rather wary of allowing an intermediary to get involved in the court process.
Yes.
I mean, I think I mean, an interpreter is quite a sort of, by comparison, quite a hard black-white line.
Yes,
at least
indeed.
It could be thought to
Yes.
be. Although, in fact, I think we've all had experience of witnesses who say that they absolutely need an interpreter and then
they don't.
Start answering questions in English anyway. But I'm just looking at how far this goes. I mean,
Certainly the rule change and the report that underpins it, the vulnerable witnesses, the vulnerable parties and witnesses rule change, that discusses intermediaries at considerable length. So it's certainly intended to be something which the civil court should be more receptive to than they used to be. That seems to be an effect of the rule change. But I'm a little inhibited in saying much about intermediaries because I've simply never myself been involved in a case that has one, and so I can't really say anything that's anchored in in sort of experience or practicality rather than just a sort of book exercise.
No, but I mean, if one of the ways in which you say we could find in your client's favour on this would be to blend together the new overriding objective, which talks in terms about people giving their best evidence.
Yes.
With Lord Justice Coulson's point that something which relates to the particular features of the dispute should encompass that which is necessary to enable the dispute to be resolved between the particular parties.
Yes.
And so there are, I'm just trying to see if that's right. I mean, there is a wider category of cases than just interpreters that it would be said, I assume, logically follow your argument.
Well, as I say, I'm just a little, inhibited because I don't myself feel I have a very clear understanding of what intermediaries actually do.
Are there any other? I suppose I could put it. I mean, intermediaries I can obviously think of.
Yeah.
What about others? You just simply say anything which is reasonably incurred. I mean, so reasonably, what's the frame of reference? The frame of reference is just.
But that's obviously a familiar concept. That's the test for any assessment of costs. And of course, though we call this a fixed cost regime, the point is that profit costs are fixed, but the disbursements are assessed.
So what is the framework or the yardstick by which you determine whether something is reasonably incurred?
Well, I suppose it's a simple question as to whether or not it was reasonable for you to have, in the instance of interpreter, reasonable for you to have an interpreter. So in the example your lordship gave,
the word reasonable is like the word fair is sort of difficult to pin down unless you give me a frame of reference there.
Well,
reasonable, what in the ordinary run-of-the-mill of litigation?
Well, it has to be because of a particular feature of the dispute. So you can't just say, we always get advices on evidence from counsel. You can no longer say that. You have to show there's some particular need for it in the instant case. So perhaps it does carry with it a sort of test of reasonable necessity or something of that sort. It's something which you need to have incurred in order to facilitate your participation in the dispute resolution process.
Or for the process to operate. I mean, like the crash reconstruction expert.
Yes.
Yeah.
Okay. I was just thinking about that. The justification for any expert evidence and the justification for any expert evidence is that they are necessary to enable the court to understand and therefore resolve the dispute. It carries with it the privilege of giving opinion evidence.
Yes.
But that is the underlying justification. I'm sure I could find it somewhere to back myself
in
up.
Part 35 or somewhere.
Somewhere like that. If you view it in those terms, there's not actually very much difference between an interpreter and an expert who is going to explain to you that the tire marks on the road mean such and such.
I suppose, perhaps the distinction that Lord Justice Coulson might make, what a strange intellectual exercise to be trying to imagine what Lord Justice Coulson might do in a given situation, is I suppose to say, well, the expert is actually helping you decide the dispute which the court needs to resolve, whereas the interpreter, he doesn't actually help you in the decision-making process, but he's still essential for there to be a decision-making process. So there is a distinction, but it's certainly one is beginning to sort of populate heads of pins with angels, perhaps. I was going then to come on to my learned friends showing you the note that seems to have accompanied the rule change, which suggested the rule change didn't apply to fixed costs. The order, as my learned friend showed you, there was a specific rule change which dealt with other sorts of costs. That was the section Part 44 that he showed you. Part 44 doesn't apply to fixed costs. This
was page 75 of the authorities bundle.
It was page 75. But I just asked, well, how does that comment help? It's not part of the rule. It doesn't have any status. It's not an explanatory note. And I simply rely on the words of the modified overriding objective itself. And obviously, what is said at page 75 can't possibly overbear what I say are the clear words about the access to justice and what it now requires the court to facilitate. Ensuring the parties are on equal footing, can participate fully in proceedings, and that parties and witnesses can give their best evidence. That can't possibly be overborne by what Mr. Brown shows you at page 75. And then, so far as he then addressed you briefly on the commentary in the report that led to the changes about vulnerable witnesses, and says, well, it doesn't focus on issues of language or interpretation. But the reason it doesn't do that is because, as the report notes, it isn't a general problem. I mean, what the report records is that there is a settled approach to interpreters in the civil courts, and they're recoverable as a disbursement. It says that at the very passage my learned friend took you to. And then, as he showed you, there's a note that just says, but see Cham and Aldred, which at that point had only just been decided. I think it was handed down at the end of October, and Judge Cotter's, as he then was, report was published in February of the following year, therefore probably written slightly before that. So yes, it's not something which addresses there being any sort of generalised problem in respect of interpreters, but that's precisely because there isn't a generalised problem in respect of interpreters. It's a localised problem which is resulted from the obiter dicta in Cham and Aldred. But here again, I say in any event, the rule change is the rule change, and whatever the report discloses as to whether or not the authors thought that there was a problem with interpreters which need to be solved, I don't invite the court to look beyond the words of the rule change which I've just quoted. And I say that if under that new mandate, when this court discharges its duty under CPR 1.2 to interpret words with regard to the rules with regard to the overriding objective, there has indeed been a dispositive change since Cham was decided. More generally, and I'm obviously, my Lord Justice Smith, Stuart-Smith drew attention to it, so I'm not going to spend any time going through this report, but the general policies which are described as underpinning the proposals, and they're summarised, for example, in submissions from people like Justice. They look at what's done in the tribunals, they look at what's done in the criminal and family courts, and they say the civil courts can learn from it. I mean, they go through that at great length. I particularly noted at pages 67 to 69. And it does lead to the overall conclusion. And it's, just for your Lordship's notice, paragraph 162. It's the Council's view consideration should now be given to the CPRC to a rule change to make specific reference to ensure full participation by all parties and by the giving and obtaining of best evidence. So that's their ultimate recommendation. It was accepted in the rule change which we have seen. And in my submission, there is nothing in this report that could possibly lead the court to conclude that somehow we can have a sort of mischief-based approach to this rule change, which allows us to be insouciant about parties being unable to recover the necessary costs of the interpreter which they need to participate in the proceedings and to give their best evidence. So that is that. Then my learned friend, I'm nearly at the end, my learned friend made some points about interpreters' terms of payment based on his instructions. We obviously don't have any evidence of what he said, and we, on our side of the court, we know nothing about it. He then referred to Part 45, 29I, using the word claim. And we're not surprised it uses the word claim because it's referring specifically to claims which are started under the protocol. And the thing that you start under a protocol is a claim. You submit something called a claims notification form through an internet portal. And that is the claim. And we say it doesn't follow from the fact that the word is used in that way. That the word claim is there used, that later when you get the word dispute, the court is in the draftsperson is intending the narrow meaning that Lord Justice Coulson alights on, so that it not only excludes features of the case, but it even involves features necessarily incurred because of a rule-prescribed dispute resolution process. in our submission, it's simply a non sequitur to say that the use of the word dispute ousts any ability to recover necessary costs of the dispute resolution process itself.
Sorry, I must confess I was struggling to. Can you take that last point a little bit more slowly? Sorry, sorry, I didn't. Keep,
No, forgive me.
Didn't keep up with it.
I was saying that the use of Mr. Brown relies upon the fact that at the beginning of 4529 it uses the word claim.
So this is 14.529. I.
So it's the disbursement rule itself.
Yes.
So let's I'll turn it back up so I'm anchored in the rule. So for people in the white book, I think it's page 1468, and obviously it's, I think, divided 9 in the. So Mr. Brown relied on the fact that at subsection 2 of the rule, it is rubricked in a claim started under the RTA protocol and the ERPR protocol and the travel claims protocol. The disbursements are, and then it lists them. And Mr. Brown said, well, there must be a significance in the word changing from claim at 2 to when you actually get down to H itself, the word dispute being used instead. And so far as claim is concerned, my point was simply, well, they're called claims because that is the thing which you start under the protocol. The protocol begins by filing a claims notification form through a portal, and then you follow a very, very closely defined process. So that is the claim that you're pursuing. What I'm saying is just because that is the terminology the protocol uses, I'm suggesting it's a non sequitur that when you get down to the costs of the features of the dispute in H, that sort of hidden within that formulation is an intention on the part of the draftsperson to oust any part of the necessary costs of the dispute resolution process, which would include the interpreter.
I think, but the point is when you look at them, I think his point was when you look at the mirror for defendants' costs, or at least, well, it's not the mirror, sorry, it's when you look at the defendants' costs a little earlier, 2 pages earlier, in other words, 4529F,
yes,
the provision I put to you, you do see a very clear distinction between the concept of the claim and something which is in dispute.
Yes, but I mean that, and obviously that's what we debated earlier. I mean, I'm saying, but that's because that is addressing that fulfills a different function, which is that what the defendants can recover is determined with reference to the value of the claim, and it's simply saying that when you're determining the value of the claim to work out, and obviously that is relevant to what defendants can reasonably and proportionally invest in defending the claim. So you look at the claim's value to work out what their costs can be. And unsurprisingly, I mean, you know, if part of the claim isn't in dispute, so they don't need to invest anything in defending it, it's disregarded.
Yeah, but you know, that is drawing a distinction between the claim as a generic thing
and the amount in dispute.
What is disputed? Well,
the amount in dispute.
Yes.
Yes.
Okay.
I mean, but that's the. I mean, you know. So that's what this is. That is what this is speaking to. It's speaking to a quite different thing from CPR 4529 IH.
But it is a legitimate, certainly linguistic point to make, is it not? That H doesn't say any other disbursement reasonably incurred due to a particular feature of the claim, or of the, you know, or the circumstances of the claim, or some such wording.
Well, no, but I mean, my answer to that is as we've seen elsewhere in this very part, I mean, dispute justice seems to be used as synonymous with case, and for example, earlier on.
No, but it isn't used as synonymous. Sorry.
Yeah, but that's
the point I'm making is.
But I think that's when you're asking what is the amount in dispute, whereas that is different from saying in my submission what are the circumstances of the dispute. When elsewhere in this case, the dispute is being used synonymous with a case, because, for example, earlier on, as I showed you, it talks about the parties to a dispute. It's something you're parties to in the same way you're parties to a claim, you're parties to a case.
That was in a different.
No, it's in section 2 of part 45, and in section 3 of part 45 there are references to being party to. So.
Okay, so in a part, but in a pre-existing part of what is a 45, of which this new bit now forms part. Yeah.
Indeed, but as I say, when the word, I mean, for example, I know, forgive me if this is a cheap point, but within the same sentence, we see the word claim being used in different ways. It's used as a hammer. We see it in the very passage from 4529I. My learned friend relies on 4529I itself, a claim for disbursement, and then it talks about a claim started under the RTA protocol. The word claim is being used differently according to its context. And I'm saying that the passage which your lordship is putting to me is addressed to simply the question of working out what's in dispute. What's the quantum? What's the contested quantum? And that is a different function than the way that the term dispute is being used as a noun in H. And H has been introduced, and H is it can't be divorced from the rest of Part 45 because it's a reiteration of the.
This is the broadest attack you make on Lord Justice Coulson's reasoning, because what you are now submitting, I think, is he was just plain wrong to draw a distinction between, or to draw the distinction he did. Because if you're right on that, I'm struggling to understand why you. Well,
because
you would say, wouldn't you, that actually the actual result is wrong in Cham?
Well, the reason why I'm not just focusing on that is because obviously it's not open to this court to say he was wrong about that, because unless one can say it's per incuriam, it's not enough for this court to disagree with him, and that might lead to this court giving leave to appeal, but it has to apply the ratio if it can't distinguish.
Yeah, so I'm just struggling to understand how we adopt this argument of yours, this link, this point that dispute just means claim when it appears in H.
Yeah.
And I'm struggling to see how you can say, well, Lord Justice Coulson wasn't.
No,
wrong.
I think as I said at
right.
I said it out. There are a number of strands I'm seeking various remedies, of which my last resort remedy is to say that your lordship should take if you're driven to apply the ratio of this case, you can't see any reason to distinguish it. I ought to get leave to appeal so this can be tested before the Supreme Court.
At least on one view, Lord Justice Coulson's reasoning could apply exactly the same way if the word there had been claim.
Yes, it could potentially. Yes.
If it had said reasonably incurred due to a particular feature of the claim,
he could make the same points.
You could opt for a narrow or a broad interpretation.
Yes, you could.
Because of the context.
I think
both these words can be shaded by reference to context, immediate context.
Yes.
And,
yes. So I mean, in a way, and obviously, I'm entirely reasonable of my Lord Justice Snowden to sort of pick me up on this part of my submission. I'm just replying to Mr. Brown saying there's a distinction between claim and dispute in this very passage, which is my Lord Justice Stuart-Smith has just put to me. Even if he's not, even if that's a distinction without a difference, it still doesn't answer the case, because even if the word is claim is there are still competing arguments as to whether it should be construed narrowly or broadly. So far as I really have just got about 3 points left. My learned friend's reliance upon what Judge Wood QC said, which I mean, again, perhaps not much turns on it, because we're not here concerned with His Honour Judge Wood. We're concerned with Lord Justice Coulson and whether he can be distinguished. But just to be clear, I do respectfully say that what the passage from Judge Wood, which he quoted, is quite unconvincing. And Judge Wood says, well, what this argument leads to is you're turning this into you get any other disbursement not covered by the above situations. That's what Judge Wood says, and that isn't what we say. We still have to show it's a disbursement which is incurred reasonably because of a particular feature of the dispute. So it doesn't become a sort of license to incur disbursements willy-nilly. You have to have a case-specific justification for it. So the analysis of Judge Wood, which my learned friend prayed in aid with great respect, we say is unconvincing. It is not just our argument doesn't lead to a free-for-all. It means that we only get disbursements that can be specifically justified, having regard to the specific facts of the case. But the specific facts of the case, we say, are that in order to resolve it and have the access to the court, there was his or her constitutional right to claim it needed an interpreter. and in no sense in my submission does the argument I advance undermine the fixed cost regime, which I think was something that was said. It doesn't. It leads to a regime which is slightly broader than Lord Justice Coulson believed, but to suggest it sort of rips away the fundamentals in our respectful submission is unconvincing. So that just leaves two things. My learned French reference to small claims. Just to be clear about this, the reason why you can't get interpreters' costs on small claims is because in general you get no costs on small claims. And I think my lady referred to a reference to fixed costs in small claims. That's what in the old days people used to call the costs on the summons. So when you put in your summons, I think it's like about £30 or £40 or something that you can write on the summons, and you get that. That's the whole extent of it. In general, there are special rules for unreasonable conduct and such like, but in general, like the tribunals, small claims track is a non-cost bearing track, so no one gets costs. For that reason, there's no issue of discrimination because everybody is treated the same. No one gets costs. But most importantly, the small claims track has its own solution to this. It's CPR 27.8. The rules of evidence don't apply to small claims, and evidence is not sworn. So in fact, on small claims, there isn't anything to stop you turning up with your English-speaking cousin or your English-speaking child or whatever it may be. There is no requirement to have an independent interpreter in small claims cases. As I say, and nor is the interpreter sworn because no one is sworn.
What's the threshold for small claims? Can you remember?
It changes. It becomes ever more complicated.
Sorry.
But for the most of the life of this case, £1,000 of general damages of more than £1,000 of personal injury, you're off it. For non-personal injury cases, it's £10,000. Okay. There are now all sorts of refinements which my Lord Justice Stuart-Smith was looking at in the case I was involved in last year around special rules for road traffic whiplash cases. Yeah. But we don't need to be. That's a subtlety I think we don't need. That's its own thing. But in general, my lady, yes, PI claims are out of small claims if they're worth more than 1,000 in terms of their general damages. My Lord, the very last point is we said given the nature of the debate we should hand in Young and Bristol Aeroplane. I dare say that you've all got it electronically, but I brought hard copies.
Thank you.
Just for your note, it's really page 729, which is the penultimate page, which discusses the per incuriam exception. So there's three.
Which is the one I remember. That's what Kelly Law cases has got nothing to do with the Young.
Right. Thank you very much.
Yes, so I was just going to say, my Lord, forgive me. So it's page 729. If you look at that, it does make there is a per incuriam exception where this court can depart from previous decisions where they're per incuriam. So I think I might have unless I misheard your Lordship at the beginning where you said that wasn't possible in limited circumstances. It is. I'm not going to address you as to where I say this case falls because you've heard the argument and you'll form your own view. So those aren't my submissions unless I can assist you further.
Okay, I was confusing this with another Bristol Aeroplane Company case in my mind, but what I do know is this did go to the House of Lords, didn't it?
It did, but not on. But the stare decisis learning, I think, is still
to be found here.
Founded in the Master of the Rolls' judgment, because obviously it's the Court of Appeal which has created the rule. It's a Court of Appeal created rule, right. But we can certainly send in the House of Lords.
No, don't worry.
It essentially affirms it.
Perfectly well with that, but
yes. Yeah. So your Lordship's quite right.
Good. That it?
Yeah. Yes.
Thank you very much. Thank you very much both, and thank you to those sitting behind you who have invested so much in the case. It will come as no surprise to you to know that you're not going to get judgment now. We will produce a draft in writing, which will be sent on the usual terms for typos and clear errors, but not re-argument. When you get the draft, the party should liaise as to an order. If you can't agree an order, then barring extraordinary accidents, we would expect to deal with matters on paper, and the easiest way that you would make that happen is to put in a draft which shows the competing submissions, and then very short written submissions in support of your position.
Very good.
I can give no undertaking as to when you will get this, but it'll be, I hope, before you start to complain. Thank you very much.
Thank you, my lord.
Thank you.
Oh my goodness. Gracious.